Article 1 of the Family Code provides that marriage is a special contract of permanent union between a man and a woman, entered into in accordance with law for the establishment of conjugal and family life. It is the foundation of the family and an inviolable social institution whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage within the limits provided by this code.
According to Article 220 of the Old Civil Code, in case of doubt, all presumptions favor the solidarity of the family. Thus, every intent of law or facts leans toward the validity of marriage, the indissolubility of the marriage bonds, the legitimacy of children, the community of property during marriage, the authority of parents over their children, and the validity of defense for any member of the family in case of unlawful aggression.
Extrinsic validity of marriage. It is controlled by the law of the place of celebration. All marriages solemnized outside the Philippines, in accordance with the laws in force in the country where they were solemnized and valid there as such, shall also be valid in this country, except those prohibited under Articles 35, paragraphs 1, 4, 5, and 6, Articles 36, 37, and 38 of the Family Code of the Philippines. In the case of People versus Mora Dumpo was married to Mora Hassan, then contracted second marriage to Sabdapal, without the consent of her father nor of the chief of the tribe to which she belongs. The first husband sues her for bigamy. The consent of either father of the bride or the chief of the tribe to which the bride belongs is an indispensable requisite for the validity of marriage. As the second marriage was not valid since it lacks essential requisite of consent of father or tribe chief, there is no bigamy, so Dumpo was acquitted.
Intrinsic validity of marriage are controlled by the parties' personal laws. According to Article 38 of the Family Code, the following marriages shall be void from the beginning for reasons of public policy. 1. Between collateral blood relatives, whether legitimate or illegitimate up to the fourth civil degree. 2. Between step-parents and step-children. 3. Between parents-in-law and children-in-law. 4. Between the adopting parent and the adopted child. 5. Between the surviving spouse of the adopting parent and the adopted child. 6. Between the surviving spouse of the adopted child and the adopter. 7. Between an adopted child and a legitimate child of the adopter. 8. Between adopted children of the same adopter. And 9. Between parties where one, with the intention to marry the other, killed the other person's spouse or his or her own spouse. In the case of Sotomayor versus De Barros, first cousins who are both Portuguese, both underage, were married in London without any religious ceremony. They never consummated marriage just for the sake of saving the girl's family from bankruptcy. Now the girl wants to declare the marriage void. The court ruled for her, saying that since Portugal makes marriage between first cousins void, it is void even they were married in London. Capacity to marry is governed by the personal law.
Marriage creates personal relations between the spouses. These personal relations include mutual fidelity, mutual respect, cohabitation, support, and the right of the wife to use the husband's family name. These are governed by the national law of the parties. If the parties have different nationalities, the general rule is that the national law of the husband will govern the parties. The exception is that if the national law of the husband is contrary to law, customs, good morals of the forum.
In the case of Jumantan versus Domingo, a Filipino man married an Indonesian woman and they wanted to fix their domicile in the Philippines. Thereafter, the Indonesian wife is to be deported after the expiration of her extended stay in the Philippines as an alien. The issue is whether or not the Indonesian wife can be deported. The Supreme Court ruled in the affirmative. There is no law which guarantees that aliens married to Filipino citizens have the right to be admitted, much less to be given permanent residency in the Philippines. The fact of marriage by an alien to a Filipino does not withdraw her from the operation of the immigration laws governing the admission and exclusion of aliens. It does not ipso facto make her a Filipino citizen.
Property relations. The Hague Convention on the law applicable to matrimonial property regimes. 1. Internal law designated by spouses before marriage, also known as the prenuptial agreement. If number 1 is absent, internal law of the state in which both spouses fix their first habitual residence. Article 80, in the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply: 1. Where both spouses are aliens. 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located. And 3. With respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity.
Annulment and nullity, as in divorce, affects the status and domestic relations of the parties. The difference lies in that the ground of annulment and nullity are based on defects present at the time of the celebration. For states with which choice of law approach is tradition, the grounds for annulment and nullity follow the lex celebrationis. For states that employ the policy-centered approach, the applicable law is the law of the state of marital domicile because it is considered to have the most significant interest in the status of the spouses. In both choice of law approaches, it is clear that since the action turns on the validity of the marriage, lex fori, which is crucial in divorce, plays no important role.
The state where the marriage was celebrated and the place of marital domicile can claim adequate jurisdictional basis to hear a conflicts annulment or nullity case. In the case, however, of Wilton v. Wilton, it was held that even a court which acquires only personal jurisdiction over the parties can grant an annulment case. An example of a conflicts case is where two parties are domiciliaries of State A. They get married in State B and get annulled in State C, the place of the husband's residence. Now, State C can exercise jurisdiction over the case, but the issue of what the governing law is remains. On one hand, traditional choice of law rules would find sufficient ground for the challenge if the lex loci celebrationis requires parental consent for a valid marriage. On the other hand, State C can conclude that since the law of State A, the state of marital domicile, gives people their age full capacity to marry, then the most significant relationship approach would not yield the ground for annulment. The choice of law rule of State C, the forum, will be irrelevant in this suit.